Hello, I'm Robert Bateman, and this is the Privacy Corner, where I talk you through my top 3 picks for privacy-related developments each week. And thank you, as always, to Privado AI for sponsoring the show. And this week, the AI Act is on the slate again. There's been a significant development, and well, I've talked about it quite a lot. So I'm going to talk you through now what happens next with this law, where we're at, where we're going over the next 3 years. Kentucky has passed a comprehensive privacy law. I'll try to sound excited about it, but it's quite similar to many others. And the European Commission has been sanctioned under data protection law for using Microsoft 365. I use Microsoft 365. I suspect you do too. So what are we going to do? Are we in trouble? Let's have a look. So the EU AI Act has been agreed by the Parliament and approved in plenary. I have on the screen, if you're watching, an arrow indicating the progress through the legislative process, and it's already out of date. I'll just colour in one of these red circles here, green, if I might be so bold, because it has now been approved in plenary by the Parliament. It needs to be approved by the Council. That is a formality at this point. Then it goes into the official journal, translated into all the languages. 20 days after that, it will be coming to force. So that means it will start kicking in gradually. And I've identified, based on this parliamentary briefing, 4 key dates over the next 36 months, starting with day 0, which is 20 days after the publication in the official journal. So within 6 months, the prohibited AI practices must end. If you are doing anything in Article 5 of the AI Act, I'd recommend you stop. It's probably illegal already. So we have indiscriminate scraping for facial recognition databases, using subliminal techniques to manipulate people, exploiting people's vulnerabilities using AI. These sorts of things and some others are prohibited from about 6 months from the adoption of the law. The general purpose AI system rules kick in after 12 months. The GPAI stuff is quite new. It wasn't in the original proposal, and it requires basically registration, transparency, very detailed level of transparency for powerful AI systems that can be used across a variety of contexts. So these are trained using at least 10 to the power of 25 floating point operations of compute, so computing power, during training. We're thinking OpenAI's GPT-3, Claude 3 by Anthropic, Google's Gemini Pro, those sorts of powerful models. After 24 months, the obligations on providers and users and deployers and so on of high-risk AI systems start kicking in. This is the bulk of the AI Act, these high-risk systems, and there are 2 types. The first are identified in Annex 3, and there are conformity assessments, there's detailed technical documentation to be drawn up, lots and lots of stuff, and these are systems using areas like education, policing, employment. You get the gist, quite serious contexts. Then 36 months after adoption, we'll have the product safety high-risk AI systems, and these are covered in Annex 2, or rather they are products or belong in products regulated under a bunch of laws listed in Annex 2, and those are product safety laws. So they are already covered and they carry a CE mark, and it's things like toys, aircraft, medical devices, AI systems used in those sorts of products. So that's a few of the dates associated with this very complicated and very long law. We've also got codes of conduct to be drawn up. We've got market surveillance authorities to be established, all sorts of things going on. Very exciting to be around at the dawn of a very important law. Of course, we've had the Digital Services Act recently, the Digital Markets Act, Data Governance Act, Data Act, NIST, NIS2 regulation, all sorts of things. Pick your favourite. This one is quite interesting for me and many others. Next up, Kentucky. I've put the Kentucky seal on the screen here, which has a picture of two men embracing and shaking hands, and a slogan, "United we stand, divided we fall." I expect that was a bit less kind of generic sounding back in the 19th century. Their new comprehensive privacy law is quite generic, though, I'm sorry to say. So this is a Virginia style law through and through. These thresholds here are identical to Virginia's. So it's the standard stuff. If you process or control data about over 100,000 consumers or 25,000 consumers and you sell lots of personal data, then you're covered. And the exemptions are all fairly straightforward. We've got financial institutions, we've got HIPAA covered entities, non-profits, we've got some data level exemptions too for PHI under HIPAA, consumer credit information, and we've got the normal sorts of rights: access, correction, deletion, portability, and opt-outs of the Holy Trinity: targeted advertising, the sale of personal data, and profiling with legal or similarly significant effects. Now, I don't want to say it's a step backwards for Kentucky, but other states have done some slightly more interesting things with this kind of framework. Kentucky really have just copy and pasted from Virginia, who in turn copy and pasted from a Washington law that never passed. It's good, of course, and it's still a very interesting scene in the US. I think that's 16 states now with what you might describe as a comprehensive law, not counting Florida. And we've also got these quite, arduous obligations: mandatory data processing agreements, DPIAs of a fashion. There's no universal opt-out mechanism provision, so you don't have to worry about GPC in Kentucky. And it's got a no sunset 30-day cure period, so you'll get a warning forever if you violated this law. Also, we have these GDPR-inspired principles: data minimization, purpose limitation, and security. Overall, it's pretty standard stuff, but well done, Kentucky, for passing something. Lastly, the Commission. The European Commission has been sanctioned by the European Data Protection Supervisor for violating data protection law. And the way they have done so is by using Microsoft 365. Now, the GDPR does not apply to the Commission. They're regulated under a different law called Regulation 2018/1725. I don't know of a short title for that law. I've always just called it that. It's not terribly catchy. So this is an interesting decision. Part of it only applies to EU bodies because they are regulated under that 2018/1725 law. Part of it, though, is relevant more broadly, and part of it would have been relevant, except that we have, of course, the data transfer framework with the US now. So let's have a quick look. I mean, I won't go through this in detail. Effectively, there are two main problems, in my view: the licensing agreement as a data processing agreement, and whatever they were using for data transfer is probably the licensing agreement too. So DPA and the SCCs. The licensing agreement does not seem to have made a very good DPA. I imagine this is some kind of standardized thing, but it's the controller's job to make sure this is right. Microsoft is the processor here, and the Commission is a very powerful controller. They really should have done a better job with this if everything is as it seems. So it seems not to have complied with their data protection rules, which are very similar to the GDPR's in this respect, not setting out the types of personal data collected, not making sure that Microsoft only does things under Commission's instructions. There is something here that is not relevant under the GDPR. The Commission and other EU bodies they can only disclose data to other non-EU bodies, even within the EU, under certain circumstances. This is under Article 9 of their data protection law. Data transfers, well, this is a bit more complicated. It seems that the Commission didn't do a transfer impact assessment, or didn't do a good enough one to cover the initial transfer to the US, and they didn't put supplementary measures in place. Now, this is pretty grating because obviously that was really hard at that time. Arguably, it would not have been possible to do it in a compliant way, but you really would expect the body that wrote the law to be obeying it. They should have used a European service provider, I guess. Easier said than done, but that's how it was at the time. Not their decision, you know, they didn't do Schrems too, but still, we have to hold them to a higher standard. The other thing is that the onward transfers from Microsoft were not properly mapped and assessed. So some lessons here do, I think, maybe take a look at Microsoft will want to have a look at their licensing agreement, and I recommend people review theirs too. Thank you so much for your time. That's it from me this week, and I'll be back next week as usual. Thank you again to Privado AI.